anymore. Today we'll talk about the Bill of Rights, specifically the First Amendment. The Bill of Rights, or the first 10 amendments, were first introduced by James Madison. They were proposed and sent to the states during the first session of Congress on September the 25th, 1789, and were ratified by December 15th, 1791. And it reads, the First Amendment reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. So basically, the First Amendment has three areas of protection for the citizen: the Establishment Clause, the Free Exercise Clause, and freedom of speech, and to assemble and petition. The Establishment Clause states that our government cannot establish one religion over another or set one religion above another. And the Free Exercise Clause states that we have that freedom to choose what religion that we may practice. The freedom of speech and to assemble and petition gives us freedom in our nation to free speech, and of course peaceably assemble and to petition our governments when we're unhappy. When at first the First Amendment, the whole Bill of Rights were proposed, the First Amendment only applied to the laws that are enacted by Congress. State and local governments could abridge the free exercise as long as there was no provision specifically spelled out in that state's constitution. However, two Supreme Court cases changed this. There was Gitlow versus New York in 1925 that ruled because of the Due Process Clause of the 14th Amendment, the First Amendment applied to each individual state, including all the local governments as well. In Cantwell versus Connecticut in 1940, Supreme Court held Free Exercise Clause is enforceable against the state and local governments. So those two Supreme Court cases added that the state and local governments had to abide by the First Amendment as well as Congress did. Throughout our nation's history, our Supreme Court has had to make judgments concerning the First Amendment, and there's been a lot of discrimination or debate on how and what the First Amendment covers. And just for a few examples, we have Dev versus United States in 1919, which tested the limits of free speech in regards to the clear present danger test. Also in that same year, Schlennick versus United States, the Supreme Court's decision sustained the Espionage Act of 1917, and the court ruled that freedom of speech and freedom of the press could be limited if the words in those circumstances created a clear and present danger for our country. Near versus Minnesota in 1931, the Supreme Court ruled that prior restraint on publications is a violation of free speech and free press. With Ross versus United States in 1957, the court defined obscenity as not merely being as sexual related material. The court also ruled that obscenity had no redeeming social importance or qualities, and therefore is not entitled to the First Amendment free speech protection. Sherbert versus Werner in 1963, the Supreme Court applied strict scrutiny of the Establishment Clause and ruled that each state must demonstrate an overwhelming interest in restricting religious activities. With New York Times versus Sullivan in 1964, the Supreme Court decision prohibited public officials from suing news organizations for inaccuracies made by mistake. So once again, the ruling guaranteed the freedom of press. Texas versus Johnson in 1989, court struck down laws prohibiting flag burning. Court held that laws banning flag burning violated the First Amendment right to free speech, and some would have said that this would have been obscene, but this was upheld. Employment Division versus Smith in 1990 permitted the government actions that were neutral regarding to religious choices. And Lee versus Weissman in 1992, the Supreme Court case held that official prayer before a public school graduation was unconstitutional, even though the prayer was non-denominational. Finally, Van Orden versus Perry in 2005, Chief Justice Rehnquist held that displaying a monument inscribed with the Ten Commandments on the grounds of the Texas State Capitol does not violate the Establishment Clause of the First Amendment. So you see that there's many rulings with many different outcomes. And what I see in regards of how this affects our government and in our future of our country is that we'll continue to see many more rulings like this where the First Amendment is interpreted in different ways. And I think we will continue to see a fight where free speech and freedom of religion is interpreted by many Supreme Court justices in different ways, and there will continue to be conflict. Although I do believe that this is an important freedom in our country, and we are blessed to have this freedom in the country, I do see it as one of those areas that people will continue to disagree on. Thank you.